Under the UK Act, it distinguishes between a data controller and a data processor. Data controller is defined as a person who determines the purpose and the manner in which the data is to be processed. And data processor is a person who processes the data on behalf of the controller. Under the UK Act, the legal responsibility, the entire legal responsibility to the provider of information rests with the data controller. However, in certain cases, both the transferor and the transferee may be regarded as controllers. For example, if two or more organizations share personal data that they process independently of each other, both organizations under the UK Act are regarded as data controllers in common. And in such event, the UK Act applies equally to both the controllers. There is no data processor in this case. The earlier example that I gave of the bank and the credit agency applies to the common controller example. If two or more organizations act together to decide the purpose and the manner of any data processing, both organizations would be regarded as joint controllers, and for any violation of the Data Protection Act of UK Data Protection Act, both the organizations would be jointly and severally liable. The data privacy rules contain independent conditions for disclosure, that's in Rule 6 and transfer conditions in Rule 7. It does not clarify what actions constitute disclosure and what amounts to transfer. The conditions for disclosure may also qualify as transfer. The conditions for transfer of sensitive data are higher than that which is applicable for disclosure of sensitive data. Disclosure of sensitive data is not permitted without the consent of the provider of information unless the disclosure is pursuant to the contract between the controller and the provider, or is made to government agencies mandated under the law, or is made pursuant to an order under the law. The data controller nor the data processor is permitted to publish sensitive data. The third party that receives sensitive data from data controller or processor is prohibited from disclosing it further. The data controller or data processor may transfer sensitive data to an Indian body corporate or a foreign body corporate, provided that the transferee body corporate ensures protection to sensitive data on the same levels as adhere to the transferor under the data privacy rules, and the transfer is necessary for the performance of the lawful contract between the transferor and the provider, or the provider has consented to such transfer. Under the data privacy rules, the transferee body corporate is required to comply with the data privacy rules regardless of whether the consent is provided by the provider and where it's not practical given the nature of the transaction. Under the UK Act, the term disclosure is used in the context of limiting the processing of sensitive data for any purpose other than the defined purpose. Transfer is used in relation to transfer of personal information outside the European Union. The UK Act allows for transfer of personal information to countries that do not provide adequate levels of data protection by use of model contractual clauses. There are two sets of model contractual clauses that have been adopted by the European Commission. The first set applies for transfer of personal data from a data controller in the European Union to a data processor in the third country. The second set applies for transfer of data from a data controller to a data controller in a third country. The UK Act also provides for limited exemptions for transfer of personal information to countries that do not provide adequate levels of protection. Exemptions include transfers made with the consent of the provider, transfers necessary for performance of contract between the provider and the data controller, transfers necessary for reasons of substantial public interest, transfers necessary in order to protect the vital interests of the data subject. Data privacy rules. Section 43 of the IDEA Act implements data privacy rules. Penalties for breach of data privacy rules. Section 43A fixes liability on a body corporate that is negligent in implementing and maintaining reasonable security practices and procedures, and such negligence results in wrongful loss or wrongful gain to any person. There are certain limitations to 43A. Proving wrongful loss or wrongful gain where sensitive data is involved is difficult. The Act does not provide for penalties for breach of obligations under the data privacy rules that relate to collection, processing, disclosure of transfer of sensitive data. Under 72A of the Act, any person who is providing services under a lawful contract secures access to personal information with the intent to cause or knowing that is likely to cause wrongful loss or gain, and discloses such personal information to any other person without the consent of the provider or in breach of the contract is punishable by a term of up to 3 years of imprisonment or a fine up to rupees 5 lakhs or both. The certain limitations again to 72A applies only to personal information obtained under a contract, and once again proving wrongful gain or loss where sensitive data is involved is difficult. It also provides for criminal liability but no financial compensation to the provider. The Recipient Provision under Section 45, which provides for a compensation of 25,000 rupees for breach of data privacy rules. Considering that data privacy rules seek to protect sensitive data, 25,000 rupees would be minimal. Data privacy rules is not fully general data protection legislation. The primary aim seems to be to address the concerns of the outsourcing industry and to satisfy the requirements of the European Union Data Protection Directive. But it will certainly assure the European customers of Indian outsource providers that any data that they transfer, personal information that transfer that qualifies as sensitive data is from now on secure in India. The government has been quick and sent positive signals by providing clarifications to the initial concerns under the data privacy rules. Hopefully, there will be more clarifications to unresolved issues and any new issues that may appear. Finally, I believe the proposed Privacy Act or the clarifications to the data privacy rules should consider the basic data protection principles contained in the European Union Data Protection Directive, which is followed by 30 countries, 27 member states and 3 European Free Trade Association countries, and the basic data protection principles existing in other large data exporting nations, so that the Indian businesses are not unduly burdened by complying with distinct set of data protection legislation. Thank you.
This is microphone after microphone pointed at my face. So one of the problems of going last on a panel discussion is that most people talk about the stuff that you want to talk about, and so you end up with very little unique material to talk about. So if I repeat what the other panelists have talked about, please excuse me, I didn't sort of do when I was preparing. It was not my intention to sort of mirror other people's things. So what I would like to do, and I don't have a presentation for you, so just shut that down. Partly look at a theoretical sort of framework within which to look at why we need a privacy law and where we are today and where we should sort of look to go. Now, Colonel Thomas talked about the need for looking at more fundamental concepts of, laws that, effective delivery of justice. But unfortunately, we've got to sort of figure out, we've got to confine ourselves to the topic in hand around data and data privacy. So let's try and define what privacy is to sort of start. So I have a CIS definition which I quite like, which I use as a sort of professional guideline. So privacy is the right of an individual to be free from unauthorized intrusion and the ability of that individual to control or disseminate information that identifies or characterizes the individual. So there are sort of key operative, so two sort of limbs, if you will. One is the right to be free from unauthorized intrusion, and the other is the ability of the individual to control how information regarding to that individual is collected, disseminated, and used. And so it's, so let's sort of think. If you look at the theoretical frameworks, there are two sort of primary, well, if you look back to the 1980s or the late 1970s, the OECD came up with a framework within which to apply, with which to examine privacy. So the OECD has 8 basic principles that guide data privacy and data protection. And that, I mean, though the EU likes to say that they were independently discussing data privacy at that time, the OECD principles seem to be the sort of basic, the basic framework. So if you look at, there are 8 principles. The principles are sort of collection limitation, which is essentially collect only what you need to collect. The quality of the data, sort of self-expressive. Purpose specification, collect data for a particular purpose. Please tell me what the purpose for which you're collecting data is. Limit the use of the data to the purpose for which it is collected. Properly secure the data that you're collecting. Openness, sort of tell me what you're going to do with my data. Look at where you're going to store the data. Tell me how you are going to use my data. Individual participation, which is the right of the individual to examine the data that an organization holds on his or her behalf and say, yes, this data is accurate, this data is not accurate, and sort of thing. And accountability. Intrusion, and then sort of collection and use of personal data. If you look at our legislative system, I think the problem lies more, if you look at the IT rules, clearly it excludes statutory bodies and governments from the purview of the reasonable security, whatever rules that they're called. Clearly, that in and of itself is a big problem with any sort of regulatory framework that governs data. The state and various arms of the state are probably the largest collectors of data, with one exception in India. The exception being the telecom industry. If there is one technology that pervades India today, it is mobile telephony. When you look at mobile telephony is basically a data-driven business. So without sort of going into details of client confidentiality sort of grounds, 90% of India, 90 or 90-odd% of India's mobile telephone consumers are prepaid consumers, and mobile companies use an amazing amount of data. So I'm told that there are more than 300 individual parameters that can be tracked, and if you can track 300 parameters and combine them in pretty much any shape or form to run campaigns around usage. So let me put it this way. You can use 300 different parameters to track where you get. So a lot of people here, if you use prepaid telephone cards, you probably get offers which say, you've used 50 minutes, or you use a 500 rupee pack, buy a 2,000 rupee pack for 5 months, pay for 4 months, get the 5th month free. You'd be surprised at how targeted those ad campaigns are. They know who you are, they know what you use, they know what sort of usage you're doing, and that campaign that comes in is tracked to you. They also track the completion of the campaign. Okay, so essentially, if they send out SMSs to 1,000 people, they have ways of tracking what conversion rate they had on that campaign as well. Which in and of itself is not a problem, right? So you want to know if you can save 500 rupees on a student budget. That's a great thing. I remember when I was at law school, we used to scrounge. We had a method for raising funds, which basically meant walking the corridors of the hostel and collecting 5 rupees from everybody. Because if you ask somebody for 50 rupees in the 90s, they would likely want the 50 rupees back. But if you collected 5 rupees from 10 people, the chances are that your friends forgot that you owed them $5. So in that sort of a thing, when you're still sort of living on a student budget, saving 500 rupees on your mobile bill can be a big thing. And if you can sort of scrounge up the 2,000 rupees, you would take it. That's fine. So, but the same data, the same 300 odd parameters are available to anybody who wants to track that data. And this is where it gets interesting, right? So the license conditions on which telecom licenses are granted is granted under the Telegraph Act of 1885. Okay, so let's just put it in context. A technology which is relatively recent, governed by a license that is granted under a statute that was drafted when Sir James Stephen was probably still alive and kicking, as Professor Jogarao is very fond of saying. And what is really creepy about it is the fact that the license requires telecom providers or license holders, ISPs and other license holders, to provide proactive disclosure to the government if required by the government. So here's the thing. So when you say proactive disclosure, that's a sort of double-edged, it's a fairly dangerous thing, because essentially that requires a license holder to monitor in order to proactively determine that there is a problem which the government may be interested in and therefore disclose. So to me, that sort of that would quite sort of fall within within the ambit of what I would call unauthorized intrusion. I don't know that my behavior is being tracked using predictive analytics, for example, to come up with a pattern that that somebody deems problematic. Now, there are so many different subjective elements in there that I would be tremendously worried. So let's take an example, and it's not from the telecom business. Surveillance camera at a petrol pump. Okay, so you drive up at a petrol pump, there's a camera that focuses on your license plate. Okay, so then you swipe your credit card at that petrol pump. So here's the thing. So they have a timestamp for your credit card swipe. They have a timestamp for the video surveillance thing. In and of itself, not a bad thing. I mean, what is the harm with knowing that you were at a petrol pump, filling petrol thing? But imagine if that data was available to a insurance company that wanted to track whether you were using your car in a particular fashion because they didn't run patterns around. Say you were driving on Hosur Road, which is prone to accidents, and therefore they want to build a profile of people who travel from Electronic City to the town and therefore charge a differential premium. It doesn't happen in India, but the potential to do it exists. Okay, so therefore, when we look at data and how data is used, we are not necessarily, we focus in excessive or on the likes of internet companies collecting data. We will get to that. There is creepy behavior there as well. But we will sort of, even other things, video surveillance information that's stored on at a store and then is used against facial recognition software to see if there are patterns for shoplifting. Okay, but by the same token, they could sort of, you'll know that they could, if you frequented, say, Mother Care and Mom and Me and things like that, you bought certain types of supplies, people could know that you have a young child. You really want the world to know whether you have a young child and whether that data is sort of there. And from the way you look at the data security or the information IT rules, it is not clear whether using facial recognition software together with swipe data is necessarily protected by the IT rules, and therefore you have a problem with a gap between where information is being applied by private and public sector entities and the protection that's available. If you sort of the other problem with sort of statutory rule-based organizations is that technology moves really quickly, right? So how many of you know that the ads you say displayed down the right side of most websites are actually auctioned in real time? So there is a process whereby websites use real-time tracking information to essentially determine whether you are interested in a particular kind of thing. So you could be on the New York Times' website and you could see ads that pop up saying, buy a plot on Sarjapur Road. Now really, the New York Times doesn't know that you may be interested in plots on Sarjapur Road. The only way they do it is because the platforms that underlie these times, especially people like Google, run real-time auctions, which say there are tracking cookies that show up. Say you visited a builder's website, say, and you sort of search for say, let's take 99 or magicbricks.com, or on magicbricks.com you search for properties, apartments in the outer ring road, Sarjapur Road area. There is a good chance that that a tracking cookie was created, which is essentially goes back to a media company somewhere in India, probably somewhere in Bangalore, probably, which is then tracking your behavior across websites. So when you hit the New York Times website, they've auctioned off they've sold their media capacity, their ad capacity to a company, probably Google. Google runs a thing which notifies various companies that are interested in you that this particular cookie has shown up on this website. And they actually auction this stuff in real time. In 100 microseconds, you will get an auction, you will get a winner, you will get an ad that's populated. Now that's the level of tracking at which, that's the level of sophistication which tracking is happening. And if you think that our rules are sort of adequate to track that sort of behavior, I would say that we're very far from that. The problem with it is not so much that it's happening. Okay, I don't mind being told that there are places, that there are properties for sale on Sarjapur Road. I actually probably want to know that. The problem with it is that you're not informed about it. And unless, in India, unless you fall within these sort of, limited categories of data protection or whatever, if you're a data controller that's, so my interest in properties in Sarjapur is not private data or sensitive personal data under the IT rules. So clearly, I have no protection on how that data is collected, used, disseminated. And that's really where the problem is. There is no technology neutrality in our legals, in the way the rules exist. There is no horizontal applicability to the way the rules exist. So a insurer, for example, that uses data collected from various sources, or the government that uses data that's collected from various sources to build predictive patterns around behavior. Even simple browsers, browsing data, for example, you search for particular kinds of data, or you conduct so many searches. All of that actually allows people to build fairly complex and fairly accurate behavior profiles for you. And that's the problem that you really need to worry about. And the problem with it, I won't even call it a problem. I'm saying it's the fact that it happens without your knowledge and without your ability to control it. That's where the problem is. So that is not just dissemination of data. It falls in the gap between surveillance or rather, you need to have a law which deals with unwarranted intrusion into your personal life, and also the way data is collected and used. And it's only if you have a comprehensive framework that you can actually sort of be a willing participant in this thing. I don't mind. So there's a company called InMobi that's really sort of famous here in Bangalore. They built their business model around the free ads. So if you guys download, how many of you have not played Angry Birds? Is there anybody in this room that has not played Angry Birds? Okay, so if you play the free version of Angry Birds, you see the ads that scroll along the top of the thing, because that's the way that you get, somebody's paying for you to play Angry Birds for free, right? So InMobi is the company that actually runs those ads across the top. So they use tracking technology to figure out who you are, why you are, and then track. So if you ran an ad which said, free sauna in Iceland, you're not particularly interested in a free sauna in Iceland. So obviously the advertiser who's paying for the free sauna, who's advertising sauna in Iceland doesn't want to pay for you. So companies are using fairly sophisticated technologies to track where you are. By signing up to playing free Angry Birds, you're actually agreeing to be served those ads. And so that comes to the point about being regulated by contract, right? So if you look at contract, and we do a lot of this work for our clients, we prepare terms of contract where you click and you agree, or you don't get the service. Okay? Now, I don't think it's a particularly bad idea, because my clients are spending time and money creating stuff that y'all are using, and most often for little or no cost, right? So we all love the ability to get stuff for free, okay? But that comes at a cost, there are real people behind it, real salaries, real data costs, real electricity costs, real telephone bills, and all of that needs to be paid for. And so that's why companies use data-based technologies to say. The world has recognized that this is a legitimate interest, and people like the European Union regulate it at a fairly complex level to say, Yes, you can collect data. Yes, you can use the data. Yes, you can create predictive models, but the individual must have a significant degree of control over it. And companies have made great economic models out of serving the EU with these freemium models. So it is not that companies can't do business with a far more sort of involved regulatory system. It's just that India doesn't seem to think that a comprehensive regulatory system is needed. Maybe because, like Colonel Thomas said, we've got 300 million people that can't have a full meal or proper meal, and therefore our priorities are different. But there is still a significant, hundreds of millions of people, I would submit to you, sir, that there are hundreds of millions of people that have a legitimate interest in this sort of thing. So while social engineering and social upliftment and delivery of justice is important, the fact remains that that's not an excuse for not being having an effective regime. Privacy will be the next big battleground. There is no doubt about it. Privacy will be the next big battleground. After consumer rights, this will be the next big battleground between organized businesses, I think. And actually, from our perspective, we believe that it's better for businesses to have a stable regulatory regime. For example, I was in a debate, or rather in a discussion with a leading venture capital fund. We were discussing whether their portfolio companies were actually building privacy into the engineering of the product. So think about it. If you're a technology company that uses data as the basis for your business, so you're a company. I mean, I don't know. Let's take Redbus. I mean, if you use Redbus to book your itinerary, your book a bus ticket, the credit card swipe data, or the financial data that you submit to Redbus is probably protected. But the stuff that you search for, Bangalore Ananthapur, or Bangalore, or Bangalore, Goa, so you're going to go on a holiday. That data is today probably not treated as private data. They probably are using that data for something else. And if tomorrow the law changes and you have to re-engineer all these platforms, there's a significant economic cost attached to it. So the fact that India is dilly-dallying about privacy actually works badly for businesses. Okay? And so we're actually advising clients saying that if you're thinking about setting up a business that is based on data, think about using a framework or engineering and business framework that essentially adopts probably the European Union model, because that's the gold standard. India will trend that way. It may not happen today, it may happen 2 years from now, it may happen 5 years from now, but at that point you don't want to have to, I mean, if you build a big business, you really don't want to re-engineer your thing. But people, I mean, unless there is an imperative, people aren't really sort of willing to take that sort of time and effort, and that's really sort of a problem with this country. So it's for those reasons that clearly we've seen the issues that sort of plague the rules. One is the fact that it is limited in its exposure, in its application. Two is that it has this really vague definition of body corporate, that sort of thing. Why does it matter whether it's a body? First of all, a body corporate under corporate law has a very specific meaning. An association of individuals is not a body corporate. It's an association of individuals. So clearly we want anybody who collects data should be subject to legislation. So you should have data controller, a data processor, a data subject, and a regulator. These are accepted norms. These work globally. Why do we have to recreate the wheel with sort of, with contrived definitions? So if I had to say, I'm sort of paraphrasing the AP Shah report, and it's so a tech-neutral, globally interoperable framework, which is technology neutral and multi-dimensional. So it's whether it's sort of virtual, physical, biological data, not biometric information, biological data, horizontally applicable across all categories, which has a decent regulatory environment. And I'm not a big believer in self-regulatory organizations. Self-regulatory organizations are sort of inherently conflicted. They are sponsored by entities that have an interest in economic interest. We'll leave it at that. So SROs are an interesting concept. But I think maybe like industry regulators like the RBI, for example, which probably does the best job, is a good place to be. I think it's good for businesses. It's good for individuals. We're never going to we should also accept that rulemaking is never going to keep pace with where the world is going. So so don't even sort of kid ourselves that we're going to be ahead of the curve, but at least by some sort of means, try and make it not as prescriptive as having 7 or 8 categories saying, these are the only categories that constitute sensitive personal information. Why only sensitive personal information? Why not other personal information, stuff that allows you to build character profiles or behavioral profiles? Why not cover all that sort of stuff? And contract is not a model for regulation. Contract is a I can agree by contract to waive certain rights that I have, but I don't want to have to rely on a contract form in order to create the protections that I want. I don't mind waiving those rights by way of a contract, but I think you have to have a charter of rights, if you will, a charter of obligations, and then individuals have the right or the ability to contract out of it. That probably works quite well. The model contract clauses, which I'm really familiar with. So when I joined Infosys 10 years ago, so we were first. That was the time that the EU started pushing out, also companies in the EU started pushing out model contract clauses, because till then India was still not doing work. It was mostly Y2K type of work. So really there wasn't that much data that was coming through. These were the first sort of things where we were actually having access to production databases. BPO had just sort of started, so actually people were accessing data. So the model contract clauses work great for the European Union's regulatory framework, but that doesn't give Indians or Indian citizens and Indian nationals the ability to protect their data. So we should sort of, there is a view, especially in the services business, that because they sort of have ISO 27001 or 27000 and BS 7799 or ISO 27799, that they are data protection compliant. That is not necessarily the case. They are data protection compliant as far as the data of their clients is concerned, but when it comes to the data of their own employees and other participants, there's still a long ways to go. So clearly, India needs more. India needs to think about where we want to go as a country with respect to data, and then sort of enact. Everything exists. There are no excuses for hiding. I mean, the AP Shah report, Justice AP Shah report, does a great job of laying out theoretical frameworks, comparative frameworks, legislative, where the legislative issues are, where which law. So I mean, there is nothing that we really need to do apart from sort of draft. And in fact, I think Bhairav and CIS and people who are interested have what he dislikes descriptor as a citizens bill, but there is a bill out there which we can work with. So it's clearly everything exists, just needs to be done. So, okay, thank you very much for your time.
Because it's a lot of, we also ran out of time, but it's a lot of ground to cover. But if I'm not mistaken, I think everyone has agreed on the need for, as Samuel put it, the need for some sort of legislative mechanism to secure privacy. Right? Contract is not a model for regulation, is what you said. So in that case, we need to find out what a proper model for regulation is. As I understand, we have about 10-15 minutes, so perhaps we should throw this open right now to the audience if you have any questions to the panelists. I do, but we go first. Yes, come. So could you speak into the mic? And
I not suggesting that there's no need for a law because a lot of people are underprivileged. But the need to protect them, or need to consider protection of such vulnerable sections is far more when you propose this law. I'll just give you an example. There are several people who have come and told me that although UID is voluntary, when they go to admit their child into a government school, the parents are told you go and get the UID number. Now here is data being extracted under the guise of whatever welfare or whatever it is. At the same time, a claim is made it's voluntary. How do you protect? And those people don't even know anything about it. The same applies to many of the people who go to a ration shop or for rations or there. And many of these people, they don't understand the form. If you go to any of these enrolling centers, the form is filled by somebody else. And this person merely puts his thumb impression there. He does not know what he is agreeing to. How do you protect such people? I'm not talking of data. I'm talking of protecting people. They don't even know to whom they are giving the data.
So I can, and in order to, I think there is no, the only way you can protect them is by people like us who have the ability to understand it, ask for a legislation that ostensibly protects our interests and by extension protects their interests. I don't see, I can't see of any, it would be nice to be able to have a fully inclusive dialogue, but is it practical?
I can maybe answer it when I come to the fourth session.
Any other questions? Yes.
I would be glad if you could throw some light on the jurisdiction issue.
Could you address it to identify which member of the panel you want to?
Anybody can answer.
No volunteers.
Okay. So the jurisdiction, especially when you say data, processor line in India is very understandable because getting immune importing data there, but also with the countries like Philippines coming up with the outsourcing profiling and care with the IT support that it provides, there's a lot of outsourcing or the data export also which is happening. So how is the jurisdiction issue handled here?
Raghunath, you want to take this?
Well, so you are contemplating a situation where there's a transfer of data from an Indian organization to Philippines. See, what the rules require is, it requires the recipient, the transferee organization to comply with the data privacy rules. So, of India. Of India. So obviously I would think that the contract would be governed by the Indian law.
So if there's a violation in Manila, in Philippines, which courts will have a jurisdiction?
But it depends. In the contract, there's again, the law governing the contract would be the Indian law, and you could seek an interim relief in Manila as well.
So you then go back to the CPC reading the cause of action and the jurisdiction based on cause of action?
Well, no, we are talking of the law governing the contract. So
No, sorry.
So you will, the fact of the matter is that you have, there is a data controller that collected the data in India.
Exactly.
Okay, so there is a set of obligations that's cast on the data controller under the IT rules. Okay, and so as the data controller transfers that data out of India to the Philippines, that entity will then create a contractual relationship that will provide for a dispute resolution at a general level, at the contract level. That could be a court in India, but I don't know how you can seek. What you would also ask is for a right to seek injunctive relief in the local jurisdiction, provided that the Philippines allowed for injunctive relief. So you would then have to seek an opinion on what sort of injunctive relief you can seek or you can get. Practically, there's very little that you can do. So look at every data breach that has happened. Let's take data breaches, say Sony PlayStation Network. Nobody knows where the data was lost from. So from a practical sense, you can do whatever you want. You can see, so I go to the Philippines and get an injunctive relief. I may get compensation from the company that lost the data. Okay?
If you can establish it.
Well, I guess in that sense, it's pretty, the good thing about data is there are forensic trails that lead back to where the data was originally compromised from. So it is possible to determine with some degree of certainty where the data was lost. Okay, but you will get compensation. But injunctive relief, typically what happens is that if it's financial data that's compromised, you will then seek, you will basically pay for a reissuance of the cards.
I don't think injunction will help.
But the damage will have already been done, right?
Yeah,
I think injunction serves any purpose there.
So exactly. So it's a bit of a Pyrrhic victory, if you will, in that sense. You don't really. You better pray that that data is secure.
Exactly. See, that is the entire irony in this situation. It is very unclear.
But
Even if I was to apply the basic laws which I apply for international transactions, even there it would, I think, not fully comply with the.
data. It's milk that's spilled is spilled. You can't sort of recollect it at a very practical level. So that's really why. And here's, so jokes apart, the loss of data is actually fairly minuscule for the sort of quantum of data that travels around the world. Because if you're a responsible data collector, you will actually diligence the provider that is providing you with the services, and you will ensure that their technical capabilities are such that it is the chances of data loss are minimized. That's all you can do. If somebody made the system, somebody will crack the system. So that's a given. So let's not. It works with all systems, right? There is no theft-proof house in this world. There is no theft-proof safe in this world. There are just ways of minimizing loss. So but does that mean that you will not use a locker system? You will use a locker system because it is more secure than your almirah at home. Okay, so that's the thing. There are degrees of safety. You will reasonably assume that degree of safety is available to you. If the data collector was sort of negligent in their diligence obligations, that's probably where the problem. That's where the problems arise.
And if you allow me one more question, which is on consent. Now the requirement of obtaining the consent basically lies with the data controller or the party which has privy of contract with the data provider, right? And when there's a data processor involved, to what extent is the data processor required to supervise or control what kind of compliances or consents has data controller taken? Can I just say ignore it because the data controller is giving it to me and he's saying he's in compliance? I can be quiet about it.
I can tell you from the outsourcing industry's perspective, we have nothing to do with the consent side of things. The consent is data controller's problem. I am receiving the data that they have the required consents to send that data to wherever it requires to be sent. So if you're sending it from Germany to India, it is for you to figure out your regulatory framework, not my problem.
Does the consent answer the issue of where the information is going? It says the usage, the purpose, but does it also share whether it will be moved out of the country, out of the jurisdiction?
So typical terms of contract between the individual and the data controller will provide for export as well. The forms exist for that.
And from an Indian legislation perspective, it is okay if I just in the consent form include that there might be export of information here as a consent. That's sufficient enough?
Yeah, I think that's one of the issues that today most services that when you sign up for sharing of the data upfront, and if you don't give that consent, then you don't get the services. And therefore, this is where I was drawing from the Reserve Bank guidelines on this. And the Reserve Bank guidelines are clear. You need an explicit consent when you're sharing data of particular nature. And so, therefore, that's kind of a guideline we can see in place for